Before we get started, I'd like to say a few words about where we are. Today we're broadcasting from Stanford University in the heart of Silicon Valley. Since World War II, Stanford has encouraged its faculty and students to develop new technologies and turn them into great companies. Welcome. I'm Louis Lehot. I'm a Silicon Valley lawyer. I'm the founder of L2 Counsel, and this is my video blog series called Ask a Silicon Valley Lawyer. This is series number 5, and today we're going to talk about when to incorporate and how to incorporate. And you've probably heard the short answer, which is Delaware C-corp, and in many cases that's going to be the right answer. But I'd like to take a few minutes today to tell you about why that might be the case and why it might not. First off, though, I want to talk about personal liability. When you engage in a business, you are putting your own personal liability at stake unless you do that business in the name of a corporate entity. So a corporate entity is designed to do two things. One, it's designed to shield you personally from liability and put that liability into a corporate box. And that box can either be a C-corp, it can be a limited liability corp, it can be a partnership, a limited liability partnership. There are many entities that exist, but today we're going to talk about C corporation versus limited liability corporation or limited liability company, LLC. As soon as you start operating and you leave your current employer, if you have one, or if you start operating in a business, you really want to think about forming that entity. Now that we've gotten personal liability out of the way, I want to talk about tax. Many business advisors around you will recommend to you that you form a limited liability company because that is a pass-through entity for tax purposes. That means that at the end of the year, your tax advisor would prepare a Schedule K-1, which you would then use to prepare your own personal taxes. There'd be no tax applied to the LLC, and you would pay your pro rata ownership of the profits or losses of the entity. So your local business or tax advisor who might not understand anything about venture capital will tell you that an LLC is the best way to shield yourself from liability while protecting yourself from taxes, because you won't be paying two levels of tax at the corporate level, and then on yourself you're only going to be paying tax on yourself. That's at the beginning of a venture. Of course, you're going to most likely be generating losses. And you may want those losses to offset some other income streams that you have. And so from a personal tax perspective, the LLC might absolutely be the temporary right answer. The problem is that once you start looking for outside capital, it's probably the wrong answer for your investors. So let me tell you why. Most investors do not want to receive either phantom income or phantom losses that would have to pass through on their tax returns, whether they're venture capital firms or investing entities. They definitely do not want your shadow income or your shadow losses. And an LLC will give them that. They'll, at the end of the year, they would have to receive a K-1, and it would show either income or loss, and they'd have to put that on their returns while they never received any capital or distributions necessarily. So that really puts them in a bind. Most venture capital firms will not invest in an LLC. They won't even entertain it. The worst thing you can do to scare away a venture capital firm is to ask them to invest in an LLC. They just generally won't do it. And so if you think you're going to be needing capital in the near term from an investor, most likely an LLC is not going to be a good vehicle for you, as you would have to pass through the phantom income or loss to your investors. Now, if you're a later stage company and you're looking to sell to private equity or a very sophisticated investor, there are a class of investors out there that understand the LLC, they like it, they know how to address the tax attributes and disadvantages, and they're fine with an LLC. But if you're in a technology, life science, med device, or clean energy startup where you're likely going to incur suffer losses for 3 or 4 years, probably an LLC is not the right vehicle because of this pass-through tax issue. Now that we've talked about taxation, I want to talk about how a company operates and how it's managed. A Delaware C corporation is going to have the benefit of the very well-developed statute called the Delaware General Corporation Law, and very well and accepted practices. And how you operate and govern your Delaware C corporation is going to be very simple and straightforward. You're going to have a board of directors, a president, treasurer, and secretary. The executive team, president, treasurer, secretary, can be the same person, and it can, and that's often how we set things up at the outset, or it can be different people, and their job is to operate the company. The board of directors, who could also be the same person upon formation, it could be one person, it could be as many as you like. The board of directors' job is to supervise the executive team and act in the best interests of the corporation. That implies two duties: a duty of loyalty and a duty of care. We call those fiduciary duties. So a board of directors will always have those in a Delaware corporation or the corporation of any state, and that's how a Delaware C Corp is governed. It's governed by its board of directors. Now, an LLC can either be managed directly by its members or shareholders, or it can be managed by a board of managers. Now, the board of managers is very similar to a board of directors, but it is not required under Delaware law, and it's possible under Delaware to disclaim fiduciary duty. So the LLC is quite a bit more flexible than the C Corp, but it requires a lot of drafting. And so for many technology startups or life science startups, it's overly complicated. You have to spend a lot of time setting up structures, whereas in a Delaware C Corp, the structure is already there by the statute. So we've talked about taxation, operations, management. Let's talk about ownership. A Delaware C Corp is going to have common stock, and it can have multiple classes of common stock, and it's going to have preferred stock. And it can have multiple series of preferred stock and multiple classes of common stock. A limited liability corporation or company is going to have units of membership, and again, by contract, you can set those up in any possible way. The Delaware C Corp has a very advanced and well understood statute that sets forth how you set up the governance of those individual series of stock, whereas in an LLC, everything can be modified by contract. So if you're an early stage technology, life science, med device, or clean energy company, the Delaware C Corp is going to be much simpler for you to set up classes of ownership, whereas an LLC will be better if you have a very complicated financial investors who have different priorities and want to set those out and negotiate those. So most technology and Silicon Valley lawyers that you'll meet will steer you towards the Delaware C Corporation, but different strokes for different folks. Not necessarily the case. Whether you have a Delaware C Corp or a limited liability company, those classes of ownership, or which we call securities, are going to be restricted upon transfer until you're a public company. So whether you're a C Corp or an LLC, we're going to make sure that the interests or securities are, when they're issued, have transfer restrictions in place that make sure that we comply with federal and state securities laws that restrict transfers until a company is public. The differences between the two, let's talk about that for a second. Once again, in Delaware, there's a statute. How a security is transferred is governed by the state general corporation law, whereas in LLC, you have complete carte blanche and a whiteboard to design as many restrictions, covenants, springing interests as you like into the body of your security, and you have a lot of creativity and ability to do things. Although the more you do that, the more it's going to be difficult to sell that instrument later on. And so I think the LLC, once again, is really helpful if you have sophisticated, complicated financial investors who have different priorities amongst themselves, and it allows you to really accomplish their separate objectives. But again, those will have significant consequences to the future transferability. As we wrap up, investors are very familiar with common stock, Series A, preferred stock, etc. So a C corporation is something that's very well understood and will be easy to operate. An LLC will not. It's going to always be a question, what does the LLC agreement say? So if you're looking for simplicity, it's definitely not the way to go. And certainly if you're trying to talk to new investors about it, it's something that's very complex. Generally not the way to go. Now that we've talked about the differences between a C Corp and an LLC, I wanted to talk about where to incorporate your business. Here in the Silicon Valley, we often debate between California and Delaware, but wherever you are watching this video from, you might be thinking that life would be simpler if you incorporated in the state where you're located and where your employees are. Here in California, the vast majority of venture capital funded businesses are incorporated in the state of Delaware. You should anticipate that if you're not incorporated in the state of Delaware, a venture capital firm would require you to reincorporate as a Delaware corporation. The reason is that it has a very sophisticated general corporation law that is passed by a legislature that is trying to make sure that Delaware remains the #1 state in the country for new formations, and that they have a statute that is state of the art in terms of addressing the needs of corporations, their boards, and their management teams. And so the statute is a great advantage over the statute of just about any other state. And then if there's ever a dispute or a lawsuit, the Delaware Court of Chancery is viewed as the most savvy, the best court to find yourself in to resolve that dispute, as the justices are incredibly focused on making sure that the results that they proliferate are good for business, and they're really thoughtful. Now, if you were to have a dispute in California, while the judiciary is also highly expert, their priorities are less biased towards business, and therefore it's viewed as a less good place to resolve a dispute about a business. And so most corporations that are venture capital or private equity funded are going to be formed in Delaware. They're going to say that any disputes must be resolved in Delaware by a Delaware court, irrespective of any other states' conflicts of laws. So again, if you think that you're going to be looking for venture capital or third-party investment, Delaware really is a preferred venue for that. Finally, I do want to acknowledge that if you are in a different state other than Delaware, you're likely going to have to qualify to do business in the state where you are, and that's going to be meaning another filing and probably some sort of tax, and so there is a concern that there's extra paperwork and there's extra tax. Now, if you're a company that's mainly operating in California and you formed in Delaware, the only tax that you pay in Delaware is called a franchise tax. It's not expensive, and it's calculated based on either your asset value or the number of shares that are outstanding, and it's something that we can capsulate and put in a box, and it's not a material amount. But there is extra work and small extra cost involved in being in Delaware, even though your business isn't located in Delaware. That's all for today, folks, on C Corps versus LLC and Delaware versus another state. One final note, some entrepreneurs and founders have a bias towards California law because it does have a provision that says that in case of a sale of a company or another material decision that's put to the stockholders, that each class of stockholders gets its own vote. And so some founders and and operators who know that they're going to take venture capital funding feel like they have some protection in case there's a sale of the company, that they, as holders of common, would have a separate vote versus the venture capital firms who likely hold only preferred stock. So with that, I'm going to wrap it up and invite you to reach out to me if you have any questions at L2Counsel.com. Please insert any comments in the threads below and subscribe to this channel. Thank you very much.